in terms of understanding where the risks lie for community legal centres, but also where the media can be used to their advantage. And often it's just about understanding the risks and balancing up how to use the media to your advantage. So I just wanted to, I guess, start with some of the basics in terms of defamation, and I apologise if people are familiar with the defamation laws, but I thought it'd be useful just to have a bit of an overview of them. So in terms of what is defamation, defamation really is a tort. It's a civil wrong across the common law world, which is really designed to protect people's reputations. Going back pre-2005, when the defamation laws changed, there was an entitlement of companies, regardless of how big they were, to take action for defamation if they felt that the company itself had been defamed. But after 2005, there were some significant changes to each of the jurisdictions across Australia, such that only now companies with fewer than 10 employees or companies that operate not-for-profit can actually commence action for defamation in their own name. So that's why I say defamation really these days is about protecting personal reputations rather than corporate reputations. Now, in each state and territory there is a Defamation Act, a specific piece of legislation which sets out or attempts to codify various aspects of the defamation law. But sitting alongside that is the common law, and the common law has been developed over many centuries in Britain, and largely we have adopted the common law here in Australia in terms of defamation. But as I say, the Defamation Acts across all the states and territories sit alongside the common law. So, for example, there are various common law defences to defamation, and there are various statutory defences to defamation, and parties can avail themselves of either or both of the statutory and common law defences. So, as I say, they sit side by side. Now, in terms of potential liability of community legal centres, I think the first thing to note is that in Australia there is a very broad definition as to who can be a publisher for the purposes of defamation. So defamation obviously requires the publication of defamatory material to a third party. Now, often it is thought that the principal people that can be liable for defamation are the authors, the original authors of the material, or perhaps in the case of a newspaper, the newspaper publisher. But what is often overlooked is that if you take part in the act of publication, whether you have a small part or a large part, you can be 100% liable for the defamatory material. Now, there are defences for innocent disseminators such as news agents or printing presses, etc. But you don't necessarily have to author the material to be liable for it. So if you publish the material online, if you even have a link to defamatory material and you deliberately draw people's attention to that defamatory material, knowing that it is potentially defamatory, then you could be liable equally as the author for defamation. So I think that's important in the context of community legal centres who might seek to republish findings that they have come across, or they might seek to publish what they've been told by other people, that if that material is defamatory, then the community legal centre itself can equally be liable for it. And I'll come to some defences shortly, which community legal centres might want to avail themselves of. Now, recently in Victoria, at least, we had a case for a community legal centre who was threatened with defamation for a web warning that was published about a credit company, and it turned out that the community legal centre was likely covered by its insurance for defamation. So it's certainly worth all of the community legal centres out there in Queensland to check with their insurer to see whether they have coverage for defamation if they are often publishing material online. So you just might want to make a note there to check with your insurance broker or your insurer, or if you are covered by a government insurance policy, like many CLCs in Victoria, check with that government agency to see that you are covered. Now, in terms of the limitations, there is a 1-year limitation period in each state. And what that means is plaintiffs, those people that feel they have been defamed, have 12 months from the date of the publication to commence legal proceedings. And if they don't do it within that 12 months, then they will be unable to pursue their claim unless they get special permission, which is very hard to get. Now, the interesting issue in terms of internet publication is because the material can be uploaded and read at any given moment, when is it first published? Because that's really the question. And what the courts have said about that is you need to look at some evidence as to when was it first read by some person online, and that is when the 12 months will commence. If you're unable to point to a particular person who read it, then the 12 months conceivably starts every single minute of every single day, because it remains, whilst it remains online, it can be uploaded and read at any time. So that is the law in terms of the limitation period. Now, in terms of the damages cap, it's just worth noting that before 2005, anybody could recover unlimited general damages. So there are two forms of damages in defamation. One is what's called general damages, and that is to compensate people for the hurt and humiliation and distress of the defamatory material. So in terms of what is, what is actually said to be defamatory, there's various definitions, but generally it's where the material has a tendency to lower a person's estimation in the eyes of what's called right-thinking members of the society. So, the man or woman on the street, what would they think about the material? If it would lower a person's estimation in that person's eyes, then it will be defamatory. So general damages is there to compensate for the hurt and distress, and before 2005 there was no limit on the amount that could be awarded, and we saw some huge sums over $1 million for general damages. In America, of course, where they have vastly different laws, you get multi-million dollar findings, but that doesn't happen here. But after 2005, we found a cap was put on general damages, and the cap presently sits at about $340,000. So for the absolute worst case instance of defamation, you cannot recover more than $340,000 for general damages. But there is also what's called special damages, which is to compensate for specific loss, and that is unlimited. So take the example of a community legal centre that publishes material which is found to be defamatory about a finance business, a director of a finance business, an individual. And it is ultimately found that the director, as a result of the material, was defamed, but also that he lost his employment as a result and could never get work again, or he had to take a dramatic pay cut, or whatever the loss might arise from the material, then the community legal centre could be up for a multi-million-dollar damages payment, because the economic loss there is no cap to it. So just bear that in mind. I just want to mention briefly about publication and the internet. The internet, of course, is now wide spread across the globe, and we have things like Facebook and Twitter. We have, product review websites. There can be hyperlinking, all sorts of things going on online, and it's just important to always recognise that once you publish something on the internet, it is extremely difficult to get it removed for all time. It is generally thought that once it is published online, it will be accessible by someone at some point, regardless of what you as a community legal centre might do to remove it. It remains cached in Google's systems and is very difficult to remove. So just a warning that, once it's published, even on personal Facebook accounts, there can be court orders providing that the Facebook account, even though it's private, must disclose the material. So it's never going to be hidden away. Now, just to finish off on the overall description of defamation, we also have an alternative cause of action to defamation which companies can use, companies with more than 10 employees, called injurious falsehood. And that is a very difficult case to prove, because it requires not only a false and injurious publication, but it also requires a finding that the publisher was motivated by malice, and it requires proof of special damages. So unlike defamation, where the motivation of the person is not strictly going to be determinative, and unlike defamation, where you can get general damages, in order to succeed on an injurious falsehood claim, companies have to prove that the publisher was motivated by malice, and must prove that as a result of the publication they suffered a direct economic loss, which can be very difficult to actually prove. But it is an alternative cause of action that companies have. So that concludes my overview of defamation law. I want to move on now to community legal centres, and specifically web warnings and defamation. So I understand that community legal centres, one of the functions is to understandably warn the public about, to put it bluntly, dodgy companies and dodgy people out there who might be trying to rip people off. And I think it's important also for community legal centres to notify the public where they have a good result in relation to a particular case or a client, to show the community the good work that they're doing. But of course that then puts them in a position where they can be liable for any defamatory material. So there are various defences that are available to publishers, including community legal centres. I just want to name two, which are the two most relevant ones for community legal centres. One is the defence of truth. Now, it sounds pretty straightforward, but if you, as a publisher, can demonstrate that what you have published is true, then of course you have a defence, a complete defence. It doesn't have to be 100% true, but it needs to be substantially true. And to be on the safe side, you should not consider that substantially true means good enough. Substantially true means true in nearly every respect, although some minor inconsequential details might be incorrect. Now, that is where it is very important for community legal centres, if they are publishing web warnings or similar, to do their research as thoroughly as possible about the reports that they have received from clients about dodgy dealings. Because if you can have up your sleeve a detailed statement from your client about what has gone on, and you have spoken to witnesses and verified what your client is telling you, then you are in a much better position to go ahead and publish your web warning, knowing that you will be able to rely on the defence of truth if the target of the web warning is alleging defamation. And we had this similar scenario last year for a Victorian community legal centre where they had published a web warning about a dodgy credit fix company, and the web warning was based on statements that the community legal centre had taken from various clients, and they had done a terrific job in that regard. However, when we got the letter from the company saying, you have defamed us and we're going to sue you, etc., what we did is we drilled down with the community legal centre as to the evidence they had and the statements they had taken, and we found that there were some holes in it. They weren't absolutely perfect. So what we advised is that the community legal centre should immediately remove the web warning in its current form, reserve its rights to republish it, and we then assisted the community legal centre to go away and beef up the statements that they had taken from the clients that had been affected by this company. And we were then able to rework the web warning so that it was substantially true based on the statements we had taken, and we were happy with that. And we published it in a revised form. And of course we got the usual letter saying, it's still defamatory, take it down, but no action was ever taken by that credit company, and I'm pretty sure that it's because we were able to demonstrate that we had taken these detailed statements and what we were reporting was true, and we had gone to the trouble of getting independent documents verifying what our clients were telling us, and so the community legal centre was satisfied that what the clients were saying had a factual basis. But my number one tip, if you are to receive a notification alleging defamation, is to immediately remove the material and just triple check that what you have published is substantially true. And if you can do that, then you can safely put it back online, knowing that you'll have a defence of substantial truth. Now, sometimes, of course, community legal centres won't be publishing things that are designed to talk about factual statements. They might be wanting to express certain opinions, and that is where the defence of qualified privilege comes into play. Qualified privilege exists both at common law and at statute, and it is a very useful defence for publishers. What it says is, if you have, as a publisher, a duty to publish something to someone who has a corresponding interest in that material, then it is privileged from defamation, provided you're not motivated by malice. So let me give you one real-life example. We had a case many years ago of a nurse who wanted to move from one hospital to the other, and she put forward her supervising matron as her referee. And so the prospective employer telephoned the matron and said, "Oh, we're interested in hiring Nurse Jo. Can you tell me, much about her?" And the matron said, "Look, she's a really good nurse, although I suspect that she may have a drug habit." Now, that on its face, of course, is highly defamatory. But the defence of qualified privilege was relevant there because we were able to argue that the matron had a duty to notify the prospective employer of her belief that this nurse had a drug habit. And because of the ramifications of that possibly being true, it was accepted by the plaintiff nurse ultimately that the prospective employer had an interest in that material and that the matron had a duty, a social or a moral duty, to publish that material to the prospective employer. And there was no malice involved. It was her genuine belief, and she was expressing that belief partly to protect the public. So that is an example of a defence of qualified privilege. Now, where it gets complicated for community legal centres in terms of web warnings and any online publication is that how can you say that the world at large has an interest in certain specific material relevant to the web warning? Because remembering that in qualified privilege it requires that the recipient has a specific interest in the material. So that is why the mainstream media, Channel 7, Channel 9, The Age, the Herald Sun in Melbourne, etc., are not able to rely on the defence of qualified privilege because they publish to the world at large. They don't publish to a specific person with a specific interest. They publish to the world at large. So how do community legal centres get around this? Well, there have been some recent cases in Victoria where it was found that because the internet site, the relevant internet site, required people to click in several times to find the relevant material, that was enough to show that they had a specific interest in it. So my advice would be that if you are wanting to publish a web warning about certain individuals or businesses, the best thing to do is, rather than have that web warning sitting on your front page of your website, set it up so that it requires people to click in a few times. So you could have on the front page a description which simply says current web warnings regarding credit providers without naming anybody, and then people having to click on that link to go one step further into the website before they can actually see the material. That then enables you, I think, to argue that it was not a publication to the world at large, but it was a publication to people that are genuinely interested in that material. My third and final tip in relation to web warnings and defamation is to, if you have the capacity, if you have the manpower, then it is great to have some sort of system where you are vetting things you might be linking to once a week, let's say once a week if you can do it. Because although it's not a complete defence, the courts will actually look at what systems did you have in place to prevent defamation. So if you can say, well, we're a small community legal centre, we're not for profit, but we devoted 1 hour a week to reviewing our website, making sure that people weren't posting things that were defamatory, and reviewing things we were linking to, then in my view that's going a long way to showing you have a system in place. And that's what the courts, that's one of the things the courts will look at. So just to recap in terms of my tips for CLCs and web warnings, do your research so that you can rely on substantial truth. Verify what people are telling you by speaking to other witnesses and looking at the contemporaneous documents. Secondly, if you are publishing web warnings, then embed those warnings 1 or 2 clicks within your front page. And thirdly, have some form of vetting that takes place if you can, and document that system if you can as well. So that concludes my discussion of web warnings, defamation and CLCs. I now want to move on to the issue of press releases and possible waiver of privilege, because obviously CLCs want to do what they can to maximise the media exposure that they get, as I said earlier, to show the excellent work they're doing, but also to highlight to potential unlawful behaviour that CLCs do exist and they need to be careful. So what can sometimes happen is that CLCs might be involved in legal proceedings and they get some fantastic advice from their solicitors or from their barrister during the proceedings, and they want to try to convince their opponent that their opponent's going to lose because of this great advice. Now, this is where the issue of waiver of privilege comes in. So forgive me if this is obvious to everybody, but privilege, legal professional privilege, is about maintaining confidentiality of legal advice. And what it really means is if you obtain legal advice, then you are under no obligation to provide that to your opponents or to anybody else unless you want to. No obligation at all. But you may wish to expressly waive that privilege where you have persuasive counsel's advice or perhaps a persuasive expert report. So you might actually want to say to your opponents, look, you're going to lose this case because we've got this great advice. Here's a copy of the advice. You can have a look at it, and you should give up your case now. And that's fine if you want to go down that path, but you need to be very careful if you don't want to actually have to provide a whole copy of the advice. You need to be careful of what's called implied waiver of privilege. Now that's usually unintentional. And where it arises is if you act in a way that is inconsistent with the maintenance of privilege, then you can be asked or forced to provide all of your legal advice to your opponents, which can often be very detrimental to your case. So it's also important to note that it's an objective test. So it doesn't matter what you mean or meant to do when you referred to legal advice you had when talking to your opponents. It's an objective test. What would the objective person think you were meaning to do? So let's have a look at some examples to put it into context. Certainly you are able to disclose to your opponents or to the world at large that you have advice. That in itself will not amount to a waiver of privilege. If you refer to advice that you have which you say supports your case, that might amount to a waiver of privilege, but not always, depending on what is fair and consistent with the maintenance of confidentiality. So historically, prior to a leading case in 2008, historically, if you stated what the advice that you have actually says, that would probably amount to a waiver of privilege over the whole of the advice because it discloses the content. So in a federal court case, Bennett and the Chief Executive Officer of the Australian Customs Service, what happened there was the legal advisor had written a letter to the solicitors of its opponent disclosing certain conclusions of legal advice, and it was done with a view to demonstrating the strength of its case. But in the letter, they otherwise sought to maintain privilege over the body of the advice. And the federal court said, no, you can't do that. The federal court said that it would be inconsistent and unfair, having disclosed and used the substance of the advice in this way, to now seek to maintain privilege in respect of the relevant parts of that advice which pertain to the express conclusion. Once the conclusion in the advice is stated, together with the effect of it, then in my view there is an implied waiver of the privilege. So in that case, the solicitors had to provide a full copy of the advice. They couldn't just disclose certain parts of it, because what they were trying to do was to demonstrate the strength of their case and get an advantage in the litigation. Probably the high watermark of implied waiver was in a case called Rich and Harrington. And in that case, there was a statement by the lawyers which said, our client has acted at all times with the benefit of external advice and does not believe there's been any victimisation or other conduct for which compensation could properly be sought. Now, the court in that case held that there had been an implied waiver, because even though they were not stating what the advice was, they were merely stating that they had advice, and that based on the advice they thought they were in the right. The court said, no, you've waived privilege over the whole advice, and it had to be handed over. Now, things changed significantly in 2008 with the case of Osland and the Secretary to the Department of Justice. Now, in that case, there was a petition that was given to the governor asking to overturn a particular finding. And the Secretary to the Department of Justice issued a statement which said this: I appointed a panel of 3 senior counsel. This week I received a memorandum of advice from the panel in relation to the petition. The joint advice recommends on every ground that the petition should be denied. After carefully considering the joint advice, I have recommended to the Premier that the Governor be advised to deny the petition. The Governor has accepted this advice and denied the petition. Now, you might think, oh, well, clearly there's been an implied waiver there because they're stating what the advice is, they're trying to convince people of their view, therefore there's been a waiver. But the court disagreed. And what the High Court said is that the objective purpose of that statement was not to gain any advantage in any litigation, but to assure the public that due process was being followed by the Department of Justice. And on that basis, the High Court said there had not been an implied waiver of privilege. So the Department was able to hold on to the Council's advice and not have to provide it to anybody. Now, in terms of community legal centres, I have to say my view is that we do need to be very careful. Let's take the example of a community legal centre issuing a statement that says, we have legal advice that the government's actions breach the Charter of Human Rights. Well, based on cases pre-Osland, I think that would clearly be a waiver. It's inconsistent with the maintenance of confidentiality. But after the Osland case, you have to look closer at what is the purpose of the statement. So if the statement is not designed to give a community legal centre a forensic advantage in a case, and it's not unfair to the other side, then it may not be a waiver. Clearly different judges have different perceptions of what amounts to inconsistent conduct, but my advice, for what it's worth, is less is best. If you have good counsel's advice or expert reports, it's probably best to avoid references to them in your external materials. If you're disclosing the substance or conclusions of the advice, you are at risk of waiving privilege. But I go back to my initial point that if you are so happy with the advice you've got that you don't care if the other side sees it, then there is less of a risk to you in referring to the advice. But of course, in any advice, generally speaking, the advisor will point out the good bits in your case and the bad bits, and you don't often want your opponent seeing the bad bits. So that's why I say less is best. Okay, I want to move on now to settlement negotiations and in terms of confidentiality. So often it will be the case that you might settle a particular proceeding and your client's happy and there's a confidentiality clause in the terms of settlement. And that puts community legal centres in a difficult position because on the one hand they want to tell the world about their great result and the great settlement that they've achieved for the client, the fact they're getting $100,000 and an apology and all the rest of it. But of course the terms of settlement provide for confidentiality, and that is often because the person paying the money doesn't want people to know that they're having to pay the money. So community legal centres won't be a party to the terms of settlement, but in my view, if they have helped negotiate the terms, which provide for a confidentiality clause, then there is a real risk that if they go and blab to the world about what's in the terms of settlement, they could be liable for breach of confidence. What would the remedy be? Well, arguably, the remedy would be having to repay the settlement sum. Now, there's very little law on this, but it is clearly something that is a risk. So just beware of it. Now, in terms of open and without prejudice offers, you will be aware that in any litigation, from time to time, parties make settlement offers to resolve the case. That can be done on an open basis or a without prejudice basis. So an open basis, obviously, is where you, as the person making the offer, has put no restrictions on who can know about the offer. So you don't care if the judge knows about it, you don't care if the public knows about it. In fact, you might want the judge and the public to know about the offer you've made to show that you're serious and trying to resolve the case. But generally you don't want people to know, because as soon as you make an offer, there is an implication that you've drawn a line in the sand as to how much you're prepared to take or how much you're prepared to pay if you're the defendant, and you don't really want people to know, so you mark the letter without prejudice. The point of a without prejudice offer is simply that if you make an offer and the offer is not accepted and the matter then gets to trial and your opponent does not beat the offer that you made, then your opponent will have to pay all of your legal costs from the time that you made the offer. So it's a very useful sword to have and something to carefully consider at all stages of litigation, because you can make a without prejudice offer effectively at any stage. Now, there was one topic that I skipped, which was to do with contempt of court, and it's actually quite an important topic. So, during proceedings, you may wish to, as a community legal centre, issue a press release about the proceedings that are on foot. Now, you're very welcome to do that, but the danger is that you could be held to be in contempt of court, or what's called sub judice, if you are seen to be influencing the administration of justice. So the case of Hinch and the Attorney General for Victoria found that it is a contempt to intentionally publish material relating to current or forthcoming legal proceedings if the material has, as a matter of practical reality, a tendency to interfere with the due administration of justice. What that really means is you can't publish things that might influence the decision makers in the case. Now, when it's a judge, really you can say almost anything, because judges are seen to be incorruptible and won't be persuaded by what's in the media. If, however, the case is being heard by a jury, then you have to be very, very careful what you say before the matter gets to trial or during the trial. As we saw recently with the Prime Minister, Tony Abbott, who made comments in Parliament about the number of recent accused terrorists in Australia. There was criticism of Mr. Abbott because the criticism was along the lines of, well, he may now have interfered with the trial of these men. How can they get a fair trial if the Prime Minister is saying that they've done X, Y, and Z? And that potentially would be a contempt of court. So just be very careful about what you publish while there are proceedings on foot, particularly where you have a jury. And ladies and gentlemen, that wraps up my presentation. I'm more than happy to take any questions. I believe if you type them in, I can address them, or you can communicate them through Quails, and I'm happy to do that at any stage. Thank you very much, and I look forward to talking to you next time.
Thanks for that, Christian. It was a really interesting presentation. And as Christian said, if you want to type a question in the top right-hand corner of your screen there, he'd be happy to answer those now. Just while you're thinking of anything you want to ask, I was just particularly interested in what you were saying about social media, just because it's such a new area that we're all dealing with. So what would be the common traps in relation to defamation and social media, with staff talking about what they've heard or seen, that sort of thing? I'd be interested to hear your comments.
Yeah, look, I think the most common trap really is in relation to private Facebook pages or private communications, because often people think, oh well, I'm just posting something on my private Facebook page and only my friends can see it and it's not a problem. But the reality is that for defamation, you only need to publish something defamatory to one other person for the person that's been defamed to have a cause of action. So it doesn't matter that you publish it within a private Facebook page, or you send an email to your friend talking about some other person. You only need that publication to one third party to have a cause of action. So don't feel that you're safe because you're just publishing it within a private social media setting. That's the first issue. The second issue, I think, as I said, is that people often think, well, once I've published it and then I remove it, it's gone for all time. That's not always the case, because we often find that even if we, as lawyers, can convince, for example, the Age newspaper in Melbourne to remove an article which we believe is defamatory, Google still retains a cached version of it, and if you've got the right skills, you can dig it up. So I guess the bottom line is, once it's published online, the rule of thumb is that it's there forever, and it's very, very difficult to remove. So I think we have to be very careful there. And of course, in terms of an employment context, a lot of companies have policies, social media policies, about what can and can't be published about the workplace and colleagues, and often, even though, again, people might think that I'm bagging the boss just between colleagues and on a private Facebook setting, they're not going to get in trouble. Well, I can tell you there's plenty of people that have lost their job for bagging the boss on a private Facebook page. So that's another thing to be aware of.
Okay, thank you for that, Christien. I don't think there's been any other questions come in, so I think we'll wrap it up there. Thanks so much for participating and for the time you spent, especially Christien, with presenting. After the conclusion of the webinar, you'll be sent a quick survey to tell us your feedback and your thoughts and comments in relation to it. If you've enjoyed today, then there's lots of other webinars coming up that Quails is offering, and you can see those on our website page. So thanks again, everybody, and it's been great having you along.
Thank you.